Welcome back to the deep dive. Today, we're tackling a pretty ambitious task, actually.
We certainly are.
We've got this huge stack of sources, military history, philosophy, ancient law, and our mission is to map out how conflict, status, and just that raw human desire for vengeance really built the legal systems of the classical world.
Engineered them
Ah,
almost. We're looking at how justice itself was hammered out in times of crisis.
right. So we're trying to cut through all the complexity and show you the blueprints, the basic architecture of how societies like ancient Greece and Rome ordered themselves.
And importantly, these structures didn't just spring from, abstract thought. They were practical answers to survival, to empire, to stopping endless cycles of violence.
So this journey, this deep dive, it's going to show you how these massive military campaigns and intense political struggles directly led to the legal systems that defined who was a citizen, what justice looked like.
We'll go from, say, the battlefield at Thermopylae, right into the thick of Athenian court politics, and then look at how the Romans tried to bring a different kind of order to it all.
It's really a shortcut, we hope, to understanding some of the foundational ideas that underpin Western governance, even today. Okay, so let's dive in where the stakes were arguably highest on the battlefield. We should probably start with Sparta, specifically their thinking around Thermopylae and their wider goals in the Peloponnesian War. Thermopylae is so iconic, isn't it?
It really is. But the sources we have let us get behind the legend a bit. They show the decision to stand there wasn't just heroic folly, it was deeply strategic.
How so? Geographically, you mean?
Absolutely. The place itself, the hot gates, Thermopylae, it was this incredibly narrow pass back then. Much narrower than today because the sea came further inland. You had sheer mountain on one side, sea on the other. Those famous hot springs were there, sure, but the real value was that choke point.
It sounds like the perfect defensive spot.
It was, if you could hold it completely. And that's the catch the sources bring out. Holding the main pass was only half the battle.
Ah, right. There was that mountain path, the shepherd's track.
Exactly, the Anopia path. If the Persians managed to get a force up that track, and it was rough, steep terrain, they could come down behind the Greek lines, completely outflanking them. Holding that path was just as critical as holding the main pass, maybe even more so.
And that required coordination, trust, which maybe wasn't entirely there.
Well, ultimately it failed, didn't it? Which points to the complexities of that coalition force.
Yeah, let's talk about that force, because it wasn't just Leonidas and his 300 Spartans, was it?
Not at all. That's the Hollywood version. Leonidas commanded around 7,000 troops in total. You had the 300 Spartans, yes, but also about 1,000 other Laconians, 700 Thespians, who famously stayed to the end, 400 Thebans, whose loyalty was questionable, 1,000 Phocians guarding the path.
So a real mix, but still, 7,000 seems small against the Persian hordes.
It was small, especially considering the total manpower the Peloponnesian states could have mustered. And this is where we get to the core of Spartan policy, according to the analysis in our sources.
Okay, what was their real game plan then?
It seems their primary concern wasn't really saving northern Greece at all. Their hearts, as the source puts it, were set on defending the Isthmus of Corinth, that narrow land bridge into the Peloponnese. That was their homeland.
So their policy was fundamentally narrow and Peloponnesian, as the source says, protect home first.
Pretty much.
Huh.
They were reluctant participants up north. The only reason they committed even that force to Thermopylae was because they desperately needed the Athenian navy.
Ah, the fleet. So if they just retreated to the isthmus immediately, they'd abandon Attica.
Which means the Persians destroy Athens and likely capture or destroy the Athenian fleet. And Sparta needed that fleet to protect the Peloponnese from Persian landings by sea. They couldn't defend their entire coastline.
Wow, so it was this really awkward dependency. They had to risk their own soldiers far from home in a delaying action, basically, to protect the naval power of their biggest rival, Athens, because they needed that rival's power for their own defense.
Precisely. It's a fascinating strategic bind. And that tension, that unstable reliance between Athens and Sparta, really sets the stage for everything that follows, including the Peloponnesian War decades later.
That uneasy alliance or codependency obviously didn't hold. Let's move into that shifting balance of power, the consequences of Athens' own imperial ambitions.
Yeah, the cracks show pretty quickly. You look at something like the Battle of Tanagra, fought later in the 5th century. Sparta wins tactically on the day.
Just strategically.
It sort of backfires, or at least doesn't achieve their main goal. Sparta's aim was to prop up Thebes and Boeotia as a counterweight to Athens. But the battle wasn't decisive enough. The Spartans basically won and went home.
And Athens?
Athens actually comes out okay. They get a truce breathing room. It even allows them to recall Simon, a key moderate leader, which helped stabilize things for them temporarily. It shows how messy and inconclusive these conflicts could be.
And this constant back and forth, the need to fund these wars, pushed Athens towards more aggressive policies, didn't it? Like the Cleruches.
Absolutely. This is a big one. Athens starts reviving the practice of sending out cleruches. Basically, Athenian citizens settled on the land of allied states. Samos is a key example mentioned.
Which sounds like colonialism, essentially. Confiscating allied land for your own people.
It felt that way to the allies, for sure. Now, the interesting legal point the source makes is that technically, this might not have violated the letter of the Constitution of the Second Athenian Confederacy. That agreement bound Athens not to force settlers onto league members.
Ah, a loophole. So if Samos wasn't technically a league member in the right way, or if they found some other justification.
Exactly. They could argue it was technically permissible, but it absolutely violated the spirit of that Second Alliance, which was supposed to be, a partnership correcting the abuses of the First Athenian Empire.
So Athens is signaling we're back to our old imperial ways.
Pretty much. Settling cleruches, especially in a powerful place like Samos, showed Athens intended to dominate. Using its naval power to secure land and resources, it really poisoned the well.
And speaking of resources, the importance of controlling certain strategic locations comes up again and again, like Sestos.
Well, Sestos was absolutely vital. It's right there on the Hellespont, the narrow strait connecting the Aegean to the Black Sea.
It's a grain route.
The grain route. Athens was hugely dependent on grain imported from the Euxine coasts to the Black Sea region. Controlling Sestos meant controlling the choke point for those grain ships. Losing it wasn't just a strategic setback, it meant potential starvation in Athens.
Which ultimately is what happened, wasn't it, after the disaster in Sicily?
The Sicilian exhibition was catastrophic. It crippled Athens financially and militarily, and that disaster forced Sparta's hand in a really interesting way.
They needed a navy to beat Athens, but didn't have the money.
Right. So they did the unthinkable, really. They went to their old enemy, Persia, for cash. Persian gold funded the Spartan fleet that could finally challenge Athens at sea.
A deeply ironic turn.
Hugely ironic. And it led directly to the final blow, the Battle of Aegospotame in 405 BC. The Spartan admiral, Lysander, catches the Athenian fleet completely unprepared on the beach.
And the aftermath was brutal, wasn't it? The sources mentioned something specific.
Yes, the detail about cutting off the right hands of the captured Athenian sailors. Thousands of them.
Why the right hand specifically?
It's chillingly practical. These men were mostly the poorest Athenian citizens, the Thetes. Their power, their livelihood came from rowing the fleet. Cutting off their right hands meant they could never hold an oar again.
Or a weapon.
Or a weapon. It was a way to permanently disable the core of Athens' naval manpower and, by extension, its democratic power base. It symbolized utter defeat and helplessness. Athens was starved into surrender shortly after.
Which leads us straight into the internal chaos in Athens. Section 1.3, the oligarchic coup, the external defeat fueled internal revolution.
Precisely. In 411 BC, even before the final defeat, but when things were looking dire, there was this coup in Athens. Democracy was overthrown and replaced by an extreme oligarchy, the 400, with intellectuals like Antiphon being key figures behind the scenes.
But the fleet, the democratic heartland, didn't accept it.
Not for a second. The fleet was based mainly at Samos at this time. And remember, it's manned by the poorest citizens, the most staunchly democratic element. They completely rejected the coup in Athens.
So you had two governments, essentially, an oligarchy in Athens and a democracy operating from the naval base at Samos.
Effectively, yes. And the fleet solidified its control over Samos through violence. They crushed the local oligarchic faction on the island, the Geomori, the landowners, killed about 200, banished 400 more.
Wow, so this wasn't just political disagreement, it was open-class warfare almost.
Right.
Navy versus landowners.
Very much so. It starkly illustrates that divide. Democratic power rooted in the Navy and the lower classes versus oligarchic power tied to land and wealth. And violence wasn't just a byproduct, it was the active tool used to enforce which political system would prevail in Samos, securing it for the democratic cause against Athens.
This level of internal violence, the feuding, the class conflict, it feels like the perfect, if grim, setup for our next section.
Yeah.
How does a state even begin to create a system of justice out of all this? Okay, so we've seen the battlefield chaos, the imperial overreach, the brutal internal coups like at Samos. How does Athens pivot from that reality constant often lethal rivalry towards something we might recognize as a formal legal system. Let's get into 2.1, the foundation of public law and this ongoing struggle with vengeance.
Well, the ideal, the theoretical shift, is famously captured in literature, isn't it?
Yeah.
Aeschylus's Orestia trilogy.
Right, the story of Orestes, pursued by the Furies for killing his mother, and Athena establishes the Areopagus court to judge him.
Exactly. That play is often read as a kind of foundational myth for Athenian law. It depicts the polis, the city-state, stepping in, creating a formal court, the Areopagus, to take over the process of judgment. The aim is to stop the endless cycle of blood feuds where one killing just leads to another, generation after generation.
So the state is trying to monopolize justice, or at least the final say on it.
It's trying to monopolize the resolution. In classical Athens, we do see that homicide, for instance, is typically dealt with through the courts, through litigation. That suggests the state has imposed a structure. People aren't usually just going out and killing the killer anymore, not legally anyway.
But the old feud mentality didn't just vanish, did it?
Not at all. You see it constantly in the surviving courtroom speeches. Defendants will often try really hard to argue that a killing wasn't planned, that it wasn't part of some ongoing feud or pre-existing hatred, etc. They want to show it was spontaneous, maybe done in anger or self-defense.
Why was that distinction so important?
Because if they could convince the jury it wasn't part of a feud, it might seem less threatening to the social order, perhaps less morally reprehensible. It separates the act from this cycle of deliberate, planned vengeance, which the state was trying to control.
Okay, and this leads to what you call the crucial insight that for Athenians, personal vengeance and the public good weren't seen as opposites.
This is absolutely fundamental to understanding their mindset. The idea of dike hyperactu liban, literally taking justice for oneself or pursuing vengeance, wasn't inherently antisocial in their view.
How did that work? How could seeking personal revenge be seen as serving the community?
Well, the prosecutors in court would explicitly try to bridge that gap. They'd argue to the jury, these huge juries, remember, hundreds of citizens, that convicting the defendant achieved both things. It satisfied the prosecutor's legitimate need for personal justice or vengeance for the wrong done to him or his family. And it served the public interest. The argument often went something like this. Look, this man wronged me. If he's capable of doing this to a respectable citizen like myself, he's clearly a danger to all of you, to the entire community. He doesn't respect the norms. Punishing him not only gives me justice, but it protects the city from a lawless individual.
So the defendant becomes not just my enemy, but an enemy of the polis.
Precisely. They rhetorically merge the private grievance with a public threat. And the jury, composed of fellow citizens, was expected to see the validity of both claims. Conviction served personal honor and civic order.
Which connects directly to 2.2. Litigation as a kind of battlefield for honor and enmity. The courtroom becomes the new arena for old codes.
It really does. You have to remember that deep-seated Greek moral principle. You help your friends and you harm your enemies. That was considered justice in the heroic code.
And failing to retaliate if someone wronged you?
Was seen as a sign of weakness, a loss of honor. To me, it damaged your standing in the community. Conversely, successfully prosecuting an enemy, getting that conviction, enhanced your honor. Civic law didn't erase this, it just channeled it. The courtroom became the socially acceptable place to fight your feuds.
So the legal system itself was designed almost intentionally to accommodate this.
It seems so. Athens had no public prosecutor, no district attorney. It relied entirely on private citizens to initiate and pursue criminal cases, even for things we consider crimes against the state, like treason or impiety.
Why? Why rely on individuals?
It likely reflects a deep-seated preference for this decentralized, citizen-driven system over state control. They seemed willing to accept the downsides, like people clearly using the courts to settle personal scores, for revenge, or even for profit through blackmail. Sycophantia.
The system's very effectiveness depended on citizens being angry enough, persistent enough to bring cases.
Absolutely. The bitterness and determination of individuals fueled the whole process. If no one felt personally aggrieved enough to prosecute, the crime might go unpunished.
And within these feuds, certain acts of violence carried extra weight, right? You mentioned hubris.
Yes, hubris is a crucial concept. It's often translated as arrogance or outrageous behavior, but in a legal context, it often meant violence that intentionally dishonored someone, that assaulted their status as a free citizen.
Like the example of hitting someone with a whip.
Exactly. A whip was used on slaves. To strike a free man with a whip was hubris because it treated him like a slave. It was an attack on his civic identity, his honor, far beyond the physical pain. Violence, especially humiliating violence, was seen as part and parcel of how men engage in these rivalries, these ecthrai. The courts were just one more tool in that ongoing conflict.
Let's look at how this plays out in high-stakes politics. Section 2.3, Political Justice and Manipulation. The clash between Demosthenes and Aeschines seems like a prime example.
Oh, it's classic. The trial over the dishonest embassy in 343 BC, the background is crucial. There's widespread unhappiness in Athens about the peace treaty recently made with Philip II of Macedon. Philip seems to be getting the better end of the deal.
And Demosthenes was a hawk regarding Philip, Aeschines more accommodating.
Generally, yes. Aeschines had been one of the ambassadors who negotiated the peace. Like all officials, he had to undergo a routine audit, euthana, upon returning. Demosthenes seized on this procedural requirement.
He turned a standard audit into a major political trial.
He absolutely did. He accused Aeschines of taking bribes from Philip, essentially of treason disguised as diplomacy, arguing the embassy had deliberately failed to secure Athens' best interests. It was a full-blown attack using the legal system as the weapon.
And the potential penalties were severe, weren't they? You mentioned the law about bribery.
Extremely severe. Civic death, essentially. The law stated that if an Athenian took or gave a bribe to the detriment of the people, not only the individual but also his children and his property would lose their rights.
Wow. Loss of citizenship, loss of property, extending to the next generation.
It's total ruin. It shows the incredibly high stakes. Even though Aeschines was actually acquitted in this specific trial, he was a skilled orator himself. The case demonstrates how potent litigation was as a tool for political warfare. You could try to destroy your opponents completely through the courts.
And this potential for manipulation becomes even clearer under undemocratic regimes like the 30 tyrants after Athens' final defeat.
Yes, the brief but brutal rule of the 30 in 403 BC shows the legal system stripped bare, used purely for political elimination. The sources describe their typical method as apagoge summary arrest.
Taking someone directly before the council, bypassing normal procedures.
Exactly. Arresting opponents on the spot and bringing them straight to the Council of 500, which the 30 controlled, for condemnation. And there's a fascinating detail mentioned about how they operated.
What's that?
The sources say the oligarchs applied greater compulsion, basically, more pressure or intimidation on their own established allies on the council to ensure guilty votes.
Wait, they had to pressure their friends. Why?
It suggests that even their allies might have hesitated. Maybe they had scruples about condemning fellow citizens without proper evidence, even if they were political opponents. The 30 couldn't rely on normal political loyalty or shared ideology alone to get the death sentences they wanted.
So they had to resort to direct coercion even within their own faction.
It seems so. They needed that greater compulsion, along with summary procedures like apagoge, to guarantee the swift, ruthless elimination of opposition. Under the 30, the law wasn't about justice or even feud anymore. It was just naked power.
Okay, we've traced this path from battlefield necessity to the highly personalized, often weaponized Athenian legal system. Now let's shift focus to the absolute bedrock of any legal system, how it defines status, authority, and personhood, starting within the family. Section 3.1, Authority in the household comparing Athens and Rome.
Right, because the family unit, the oikos in Athens, the familia in Rome, was seen as the fundamental building block of the entire state. How power worked there was critical to social order.
Let's start with Athens. What was Curia?
Curia was the legal authority vested in the male head of the household, the Kyrios. This could be the father, or if he was deceased, perhaps an adult brother, or even a paternal grandfather. He held legal power over the dependents in the house, particularly the women.
And what did this power allow him to do, legally speaking, regarding women?
His authority was most prominent in marriage and divorce. The Kyrios had the sole legal right to arrange a woman's marriage, a process called enchaks. He formally gave her away.
So her consent wasn't legally required?
Not formally, no. And his power didn't stop there. The Kyrios could also initiate a divorce and arrange for her remarriage, even if she was already married.
On what grounds? What reasons are mentioned?
The sources point to several practical, often economic motivations. Childlessness was one. The need for heirs was paramount. Open conflict between the Kyrios and his son-in-law could be another. And a major concern was the dowry.
Protecting the family wealth.
Exactly. If the Kyrios felt the husband was mismanaging or squandering the dowry his daughter brought to the marriage, he might step in, dissolve the marriage, reclaim the dowry, or what was left of it, and arrange a new match. Kyrio was very much about managing family resources and ensuring the continuity of the male line.
Okay, now let's contrast that with Rome and the famous paterfamilias. His power is often described as almost absolute, isn't it? The patria potestas.
Legally, on paper, the power of the Roman paterfamilias was astonishingly broad. It theoretically included the power of life and death over his children, though rarely exercised in historical times, and certainly the power over their property and marriages. And crucially, it included the right to disinherit them.
He could just cut his children out of the will.
He could, but, and this is important, there were strict legal formalities. He couldn't just ignore them in his will. That would make the will invalid. He had to either explicitly name them as heirs, even if only for a nominal amount, or explicitly disinherit them, ex irredatio, often stating a reason.
So the law demanded recognition, even if it was negative recognition. Did society put any brakes on this power?
It seems so. While the law gave him this power, the sources suggest that Roman social feeling, the most maiorum, or ancestral custom, strongly disapproved of disinheriting children without very good reason.
Such as?
The sources mention needing proof that the children were plainly bad and unfilial. Just disliking them wasn't generally seen as sufficient grounds by the community. There was social pressure to maintain the family line and provide for one's offspring.
So immense legal power in theory, but perhaps moderated by social expectations in practice.
That seems to be the case. Arbitrary use of patria potestas, especially regarding inheritance, could damage the paterfamilia's own reputation and social standing. Family continuity was prized.
Okay, let's move from family authority to another fundamental status distinction. 3.2, the legal architecture of slavery. How did Roman law conceptualize the slave?
Well, there's a fascinating, almost chillingly bureaucratic definition offered by the jurist Florentinus. He says the word servi, slaves, comes from the fact that generals servir, preserve, or save prisoners of war by selling them instead of killing them.
So slavery is framed as an act of mercy, almost.
In that specific etymological justification, yes. It's a way of rationalizing it. He also notes they're called mancipia because they are manucaptia, captured by hand, seized in war. Both terms root their status in capture and preservation through sale, defining them as property acquired through force.
Yet, despite this definition as property, there seems to be an ongoing debate about the nature of slaves, especially among later thinkers.
Absolutely. Christian writers like Augustine wrestled with it. He often saw slavery as a consequence of sin, part of the fallen world, but sometimes even suggested it could be beneficial, a form of discipline for the slave.
And John Chrysostom?
He seems to have been conflicted, or perhaps changed his mind over time. Sometimes he attributed the perceived vices of slaves to their harsh environment and treatment. Other times he seemed to suggest they were inherently prone to certain failings, like being self-willed.
So there's no single settled view on whether their condition or character was innate or imposed?
No, there's this constant tension in the sources. Are they slaves by nature, by fate, by sin, or simply due to the legal and social structures imposed on them? The debate itself shows they weren't viewed purely as inanimate objects, even if their legal status was that of property.
And the legal system itself acknowledged that this status wasn't always permanent or correctly assigned, right?
Correct. The law recognized that mistakes could happen. A freeborn person might be wrongly held as a slave. There are legal procedures, causa liberalis, where someone could try to prove their free birth in court.
And the emperor could intervene.
Yes, the emperor had the power to grant what was called restitution of free birth, restitutio in Italian. This was a legal fiction, essentially wiping the slate clean and restoring the person to the status they would have had if they'd never been enslaved.
Manumission freeing a slave also created legal headaches, didn't it? Especially with inheritance.
It did. Manumission was the formal process of moving someone from the category of thing back to person.
Whoa.
But this transition could really complicate things like wills and legacies.
Oh, so?
Well, imagine a master leaves a bequest, say, some money, to his slave Stichicus in his will. Then, before the master dies, he frees Stichicus. When the master dies, does Stichicus get the money? Did the legacy vest while he was still property, and could property receive a legacy in that way? Or did it vest only after he became free? The Roman jurists spent a lot of time developing very technical rules to handle these kinds of scenarios, managing that complex shift in legal status.
This sounds like it leads perfectly into our final point, 3.3, the contrast in judicial systems. The Roman approach seems so different from the Athenian one we discussed earlier.
Fundamentally different in structure and philosophy. Let's recap the Athenian system first. You had those massive juries, the dikastai, hundreds of citizens.
Very democratic, very political.
And crucially, as we said, they didn't separate questions of law from questions of fact. The jury heard the arguments, maybe a reading of the relevant statute, and then just voted, guilty or not guilty, liable or not liable, often deciding the penalty too, all in one go.
And no judge giving instructions or explaining the law?
No specialist judge guiding them on the law or writing a reasoned opinion. The verdict was just a simple majority vote, yes or no.
Which, as you mentioned, made a system of precedent impossible.
Exactly. You couldn't build up a body of case law because there were no formal judgments explaining the legal reasoning. Athenian justice was immediate, contextual, highly rhetorical, and fundamentally unwritten in terms of binding precedent.
Okay, now contrast that with Rome. How did Roman law develop?
The sources describe a much more structured evolutionary process. It moved through distinct stages. First, you had legal fictions. These were ways the law pretended something was true to achieve a just result, like pretending a foreigner was a citizen so they could use a particular Roman legal process.
That kind of workaround.
A practical workaround. Then came equity. This wasn't a separate court system like in England, but rather a body of principles developed by the jurists, legal experts, who focused on fairness, adapting the often rigid rules of the old amicus civil law to new situations.
So jurists are key here, not politicians or orators.
Jurists are absolutely central, and the final stage was legislation, formal laws, enacted by an authority like the Senate, the assemblies, or increasingly under the empire, the emperor himself.
And this reliance on jurists led to a very different kind of legal culture.
Profoundly different. The great age of Roman jurisprudence, roughly from Emperor Hadrian to Alexander Severus, 2nd, 3rd centuries AD, was characterized by these brilliant legal scholars writing extensive commentaries, giving authoritative legal opinions, responsa, and directly influencing imperial legislation.
It sounds much more academic, systematic.
It was incredibly systematic. Their genius lay in analysis, definition, and categorization. They loved creating neat conceptual boxes for everything, types of property, types of contracts, types of legal actions. This whole intellectual enterprise culminated centuries later in the massive compilation ordered by Emperor Justinian, the Corpus Juris Cicerale.
Justinian's Code, gathering and organizing centuries of Roman legal thought.
Exactly. It systematized Roman law into a coherent, or mostly coherent, whole. And it's this tradition focused on abstract principles, logical deduction, categorization, and the authority of expert interpretation that stands in such stark contrast to the Athenian model.
Roman law aimed for universality, predictability, conceptual clarity.
That seems to have been the goal. While Athenian law was embedded in the immediate political and social context of the democratic polis, Roman law, especially as developed by the jurists and emperors, aimed to create a rational, ordered system that could, in theory, be applied across a vast and diverse empire. And it's that systematic approach that became Rome's lasting legal legacy to the West. Hashtag outro pair.
So wrapping up this deep dive, we've journeyed from the harsh military realities that forced Sparta's hand at Thermopylae through the internal violence of Athenian politics and the way their legal system embraced personal vengeance.
All the way to the contrasting Roman effort to build order through defined authority, like the paterfamilias, and especially through the systematic, abstract reasoning of their jurists.
It really highlights how deeply justice systems are shaped by their historical context, war, empire, internal feuds, philosophical approaches.
And that Athenian model, where dike hyper auto leben, taking justice for oneself, was seen as compatible with the public good, is so revealing. It tells us about a society where the individual citizen, motivated by personal honor and often by enmity, was the primary driver of the legal system.
A stark contrast to the later Roman focus on creating those clear, logical, almost universal categories of law, driven by experts and imperial authority. That Roman approach, of course, is what provided the intellectual scaffolding for so much of Western legal tradition.
Which leads us to a final provocative thought for you, our listeners. The Athenian system, for all its flaws, functioned because citizens felt compelled by honor, by anger, by rivalry to bring cases. Its energy came from private passion.
So the question to ponder is this. In a system without state prosecutors, where justice relies on the willingness of individuals to pursue it, how much does the effectiveness of that system depend purely on the bitterness, the persistence, the enmity of its citizens?
If that personal drive for vengeance cools, or if people become unwilling to engage in those often nasty public feuds, does justice itself just grind to a halt? Something to think about.